Operations Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective U.S.-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman Lundberg Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we've pulled together patent operations experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to help educate on best practices for processing and managing final office actions. The Operational Excellence webinar series is free. This is one of about 8 webinars in this series. To register for future webinars, go to the tab for educational resources on the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today will cover best practices for managing final office action responses and RCE practice. We have allowed time for questions at the end of the webinar. Questions may be submitted using the question button on the right-hand side of your browser window. You can submit a question at any time during the presentation, but the question will be held in a queue until the end of the presentation when we will take questions. The presenters today are myself, Peter Rebafoni, and Tim Grathwall. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I was a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center, which is now University of New Hampshire School of Law, for 5 years. Peter, tell the audience about yourself.
Hi, I'm Peter Rebafoni. I am the manager of legal operations at the Schwegman firm here in Minneapolis. I've been working in IP law for 17 years at a general practice firm, an IP boutique, and now at the Schwegman firm.
Great. Thank you, Peter. Tim, can you tell the audience about yourself?
Sure, Ann. Hello, everyone. Thanks for joining us today. My name is Tim Grathwall. I'm a patent attorney with and a principal at Schwegman. I've been practicing now for about 11 years. Have clients that range from individual inventors to large corporations, variety of technology, different types of technology and experience. And I also am an adjunct professor at Mitchell Hamlin School of Law here in St. Paul, Minnesota.
Well, Peter and Tim, thank you very much for taking time to be with us today. We're going to jump in with a little bit of context, and this may be very basic and review to many of our members of our audience, but we have a wide-ranging group of backgrounds in people who sign up for these webinars. So I want to start with the basics and set the foundation, and then we'll get into a lot more detail as we go through this program. So to do that, let's talk about where the USPTO final rejections occur in the prosecution process. If you think about a typical prosecution cycle, your basic steps, I would say, are obviously you start by filing an application at the USPTO, and this program is focused on U.S. office actions, not foreign. So your application's filed at the USPTO. You may have a restriction requirement, and you may optionally use the pre-examination interview program to conduct an interview with the examiner before the first office action. If you're lucky, you may get claims allowed at that point, and you're never going to get to the final rejection stage. But if the application is not allowed at that point, you'll have your first non-final rejection issue, and maybe some claims will be allowed there, but the ones that aren't will have a basis for rejection that's outlined in the document. After you receive that first office action, again, optionally, you may have an interview with the examiner, and then after the interview, assuming that you're still in a condition where you don't have claims allowed, you'll do a written response to the non-final rejection. After the examiner considers that written response, the application is either allowed or you get a final rejection that's issued by the examiner. And it's that final rejection that we're going to be focusing on today, and particularly focusing on the operational aspects around what to do when you get one of those. So again, this is just by way of background for some of our audience members. What are the requirements for a final rejection, and how is that different from a non-final office action? Obviously, the key difference is that once you receive a final rejection, the application is going to go abandoned at that 6-month deadline from the mailing date of that final rejection, unless something happens that puts the application in consideration, or puts the application in condition for allowance, or an appeal is taken, or you file an RCE. Something has to be done, some action has to be taken prior to that 6-month deadline. And if nothing happens, then the application will be abandoned. So what are the options at the point that you receive that final rejection? Tim, can you talk about, from the attorney's perspective, your options for responding to a final office action?
Yeah, absolutely. So I think Ann set this up really well, and I'll just kind of add a little bit to that discussion of the setup, what we're talking about today, and kind of why we're talking about it, the overall context. And that is that after final, the idea is that the examiner and the applicant, so myself, the attorney, and my client and the examiner, have reached an impasse. And so there are fewer options after final than there are before final. And so in that context, you have sort of a more strategic and more focused mindset in terms of, because you just have fewer options. Although now you have more options than you used to, and some of them are quite good. In particular, the AFCP, which I'll talk about in a second. But once you reach final, you no longer have a right to an interview as a matter of course with the examiner. The examiner does not have to enter amendments, substantive amendments to the claims, and they typically do not enter them after final. And the other thing is that all the statutory time period is really on your shoulders, the attorney's shoulders versus the examiner's. So you have to take one of the actions that Ann talked about in the previous slides to get by the clock and put the ball back in the PTO's court, so to speak. Going over the bullet items here on the slide, you've got you can contact the examiner and see if they'd be willing to do an interview, but again, they don't have to grant that. You can file a response with arguments. Typically, a response with arguments after final, unless you come up with some new way of explaining your position, in my experience, are not often successful with examiners, but they can be, and it's an option. You can file an amendment. The examiner might choose to enter the amendments, but typically they don't. So one of the things that the PTO did was they implemented this AFCP program. It's called After Final Consideration Pilot Program. And essentially the requirements are that you file a petition for the program, and along with that, you file a response with an amendment to the independent claim that does not broaden the claim. So it doesn't necessarily have to expressly limit the claim further, but it can't broaden the claim. So what do you do in that situation? You can file things that are like, you can tighten up the language of the claim, you can clarify features, maybe add structure in mechanical cases. This is a really good option from I think both parties' perspectives. So the examiner, it gives the examiner extra time to look at the amendments, to call and have an interview, and as well as also conduct some searching. So that program, because of those elements, if the case is in the right position, can really accelerate the timeline after final or make it more efficient and compact. And then, of course, you can file a request for continued examination, which is going back around for another round of prosecution, or you can file a notice of appeal. You could also file a continuation. There are a couple other options, but generally after final, you're looking at the application and saying, okay, have I really reached an impasse with the examiner where I'm not really willing to make any changes? I'm going to hold my position, and that if that's the case, then I'm thinking about appeal. And the next question is, are the claims right where I want them to be to go up on appeal? Otherwise, I'm looking at these other options. Anne, any additional thoughts?
First of all, thank you, Tim. Peter, what about the operations perspective on options after a final office action is received?
Great question. Just as Tim noted that you have a more limited number of options after final, the further you get down this path from the final office action mailing date, the fewer options you have procedurally to respond. Just for instance, if you file your response, you decide to file an amendment response, the examiner doesn't have to enter your amendments. But if you file them, before, up to and before the 2-month deadline for responding, you will get an advisory action from the examiner. However, if you decide to go that route at the 4-month deadline or 5 months, you have to make some decisions about whether or not that should be in conjunction with a notice of appeal, or if you need to do something else to avoid extensions of time, knowing full well the examiner is unlikely to send you any sort of response, and you'll be faced with a new procedure you'll have to do at 6 months.
Okay. So not always straightforward. Go ahead, Tim.
Yeah, I was just going to add that if you're going the RCE route, there are some additional things to think about, and typically you really do want to generate that advisory action. You want to watch out for going back around and opening up prosecution and getting the first action final. I know we're not really talking about all the substantive issues, but that is kind of an important one that I wanted to mention.
Yeah, and that's a good tip. So from an operational standpoint, one of the first things, obviously, you are going to think about is how do you docket a final rejection? And these can be complicated to docket because there are a number of different paths that you can take, as Tim and Peter just explained. So the core docketing requirement for the final rejection is that 6-month statutory deadline. Typically, that's going to be docketed as a 2, 3, 4, 5, or even 6-month deadline to file an RCE or an appeal if an allowance hasn't been obtained at that point. But from a docketing philosophy standpoint, and every organization has its own philosophy on how much you docket with respect to optional deadlines and things like that, there's a lot of other things that you might think about, such as a 1-month date to review any prior art that's been received to determine if it needs to be cited in that particular case, or docketing in the related family members for the U.S. matter that received the office action, docketing in the related family members a deadline to cite art that came in or was associated with that final rejection. Also, you might optionally docket a deadline maybe 1 or 2 months from the mailing date of the final rejection to remind your attorney to consider an interview or to file an after final amendment potentially. And then finally, the key ones are that notice of appeal or RCE deadline. And depending on the organization, not everybody dockets both of those. They might docket one or the other, or they might docket both. And so what you docket is often a function of your internal practice, and then it's also often a function of the docketing system that you use. And different systems allow for different things to be docketed. Obviously the country law and the 6-month deadline is the same, but they may have different tasks or activities set up for some of these optional things. So, Peter, I know you work in a foundation IP system. Can you talk about some example docket entries for a final rejection?
Yeah, absolutely. This is Anne mentioned. Depending on your docketing system, it may not allow for much flexibility here. Foundation IP, at least for what we docket in, does allow you to, docket. It's fairly open-ended. You can create new rules and docket dates. For a final office action, what we will typically docket is we will docket that 2-month deadline for responding, in which you want to get your response in to get an advisory action. We'd also docket, in conjunction with those deadlines, a pre-appeal brief and notice of appeal deadline. That just goes along with any time you respond, you could instead decide to go the appeal route. And what we've decided as well, as sort of a reminder that the pre-appeal brief needs to be filed concurrently with the notice of appeal, is to docket that as a separate item that runs in tandem. We'd also, supposing you don't file by 2 months, we will docket the 3-month date in which you can respond without an extension of time fee. And then obviously we're going to file or docket the 6-month statutory deadline for doing something to avoid abandonment, whether that is RC filing, notice of appeal filing, or hopefully you get an allowance by then.
So Peter, it's interesting that I don't see a docket entry for RCE, even though you mentioned it there. You don't have an actual docket entry that you use for an RCE, is that correct?
Yes, that is correct. That is something you can also do is you may want here to docket for any possible item that you could file, or so an RC that is you want to file with your response after 3 months is a really good item. You may want to add to your docketing system if you're able to remind you that you need to do something beyond just responding to this office action. Similarly, you may want to, in your docket system, docket for client-driven deadlines, whether that's internal review deadline, or even docketing a date for telling the client about this final office action and a proposal for responding.
Okay, so in the example here, we've given patent office deadlines, but you might also, depending on your view of what you put on a docket, have internal workflow type tasks on there as well, right? Or some of these optional deadlines as well. So once you've received that office action and it's been docketed, then just my next slide is just a typical law firm workflow for handling an office action, and particularly a final office action when it comes in. Peter's later going to go into more detail about specific checklist items, but I'm just setting the stage here. So once that office action comes in, typically you're going to be reporting it out to your client, possibly even having a meeting or a call with the client to discuss the options, and then determining what your response is going to be, or if you're going to file an appeal, or maybe even abandon. That report out process can really vary from organization to organization, though, because there's always the debate about should the report out letter have a substantive analysis from the attorney in it. And if you're going to take that approach from an operations standpoint, that can be very hard to get the attorney's analysis into the letter quickly. And you're always, I'm sure, under pressure to report your items out to your clients very quickly. So many law firms actually opt to have that substantive analysis come at a later point in time and use just a general report out letter indicating that they've received an office action, the response is due this date, and their attorney will be following up with them. But those are two different approaches that you can use on the report out letter and that process. Oops, sorry, I jumped ahead. Now, on the other side, on the receiving end of that report out letter, you have typically the corporate in-house IP department, and what's their workflow? Obviously, they're going to receive the report out from either their law firm or from the patent office directly, and then they may call or set up a meeting with their law firm to discuss the options and provide just written instructions to their law firm to go forward. They may have some internal meetings with the business units or the executives to discuss the options and determine if they even want to go forward. Budget constraints seem to come into these discussions as well, and after a decision is made, the budget's updated, and any expenses are authorized, then the instructions to go forward with that response will be sent back to the attorney who's handling it. Now, that's what I say is a typical workflow, and that's from my experience working with larger corporate customers. But Tim, what happens if a client doesn't have an in-house patent attorney, for example? What's typical there?
So really what happens is I end up acting in that capacity. So I'm going to help them with a different sort of process to work through really what you're wanting the client to, and what the client wants to do at this point is add the business context to the prosecution of the patent. So what do I mean by that? Is this patent tied to a product? Is that product strategically important? Have there been changes? Have there been changes with respect to our product or competitive products in the marketplace? What's the budget climate within the organization? Are budgets tight? Is there a budget? Who do I have to get approval for? All of those things. So the process can vary depending upon the client, but there's a couple of different options. So things that you can use a sort of an old school or new school version of the old school, which is just using email communications with the client that summarizes the rejections and the status of the application and where you're at and what your options are, and requesting for instructions. Go ahead and prepare the response, and don't prepare the response. We want to abandon this. You can use that email communication or a letter. That's why I call it kind of old school. And that actually can be pretty efficient, but for a lot of clients and a lot of us in general, we are overwhelmed by our inboxes. And so what I find is that having a regular periodic meeting, whether it's once a month, twice a month, once a quarter, to discuss everything on the client's docket, all of these actions, so all the final office actions, along with, we'll support that effort with a report, typically a spreadsheet, but it can come in other forms. It could be a memo. The nice thing about that for clients is that it's a meeting, first of all, so they can put it on their calendar. It's a known period of time. It doesn't gum up their inbox, and then they can get on that call and usually deal with most of the issues right there with the attorney support. So I can explain to them what the application's about, what the status or the procedural stance of it is, and the history and what our options are in relatively short order. And they can ask questions, which is very nice. One of the things that's hard about the email communications, both in reporting as well as substantive communications, is the clients that are not IP attorneys have questions invariably. It's very hard to draft those emails without them being laden with jargon and things that can be frustrating and confusing for clients. So I find that those regular meetings, while they're not always the most efficient way to deal with things, they do work really well for a lot of clients that I've worked with.
Good tips, Tim. Going back to my experience, which was more with larger companies that had in-house counsel and in some cases very large in-house departments, oftentimes there would be reports that the in-house counsel would require that the outside counsel provide. Tim, can you talk about some examples of the types of reports that in-house counsel might ask their outside counsel to provide when a final office action is received?
Yes. So I've worked with larger clients that have their own in-house IP department. And in that situation, typically they know exactly what they want to see. So in terms of the report, what is the report? Typically it's a spreadsheet of some sort or a matrix. And it's going to list the different matters or applications that are coming due, and basic information about that matter, like the title, the application number, the publication number, the priority date, so on and so forth. It might list abstract or first claim, depending on, but usually it doesn't actually list that. It usually lists biographical information about the application, just so the client can identify it, and then you talk about the substance during the meeting. If with clients that I've worked with that have their own department, you'll work with them, or they'll tell you exactly what they want that report to look like. It can come in memo form as well. It can be less formal. So I've had clients where I essentially say, hey, let's meet once a month, and before that meeting, a couple days before, I'll send you an agenda. And that agenda is essentially a report. It's a memo saying, okay, we need to talk about this application. This is what it's about, and this is what I need to know from you. And I'll ask them for specific input. On the other side of I guess one other example is just sort of a standard report that we can generate automatically, essentially, from our docketing database and our file management database. It's the same kind of thing, except we're dictating what's on that. So, but you can really tweak that report, and that's kind of part of the process, is figuring out what information is best to put in front of the client so that they can quickly and somewhat painlessly understand what's going on and address the matters.
Good. Well, whether you are conveying information with a report, or you are having oops, did I skip a slide? No. Okay. Whether we're conveying information with a report or you're having a meeting to go through it, there's some logistical ways sometimes to deal with providing the information, because maybe the client is wanting to see a lot of the prosecution documents. And one example that I've heard that some people use is if they send an agenda, like you said, Tim, for the meeting, then they set up a Dropbox folder, for example, and they put the prosecution documents out on the Dropbox folder so that they can then get on the phone and maybe do a screen share and look at the documents together as they're walking through and trying to make decisions on what they're going to do, whether they're going to pursue that application or not.
And a lot of times, I'll just add that depending on what the client requirements are for what information they want to see, that'll drive operationally who's doing a lot of the prepping of that report or spreadsheet, or keeping a box folder up to date. And so depending on what the client requirements are and the size of your law firm, you may have a requirement that the attorney is doing all the legwork on those reports, or you may have such a mass of data requirements or analytics requirements that you'll need a separate dedicated group to prepare those.
Wow.
Yeah. The other thing I would just add that the Dropbox works well. There's one of the challenges with these reports for clients is they get them once a month. Their engineers, engineering managers, VPs, in-house counsel that are not IP attorneys. The reports are a bunch of text with abstract titles and numbers that they don't always, they're not always familiar with. One of the easiest ways to talk about a patent application is to pull it up and point and say, look at figure 2. And so it's nice sometimes to have those documents or some way of conveying that, because otherwise those reports can be difficult for clients to review. The other thing I would say about process, kind of at a higher level, is I would encourage clients or people that are managing their own portfolios, to think about who's in charge of this and what's the best process for that person. So whoever is the stakeholder, the real decision maker that's tasked inside the organization, if email communication is their preferred method because they don't prefer to get on the phone and talk with people directly, they actually like email, then I would encourage people to take that into consideration. And because it can be, you really want that process, especially in the context of final office actions where you're on a shorter timeline and fewer options, to work for your client versus working against them. And generally, I think the attorney can do it either way. They can kind of adapt.
Good. Well, however the information is conveyed and whether there's reports or not, ultimately that information is being provided because the client wants it to help decide from a strategy standpoint whether they're going to continue pursuing the application or not. So, Tim, can you talk about some of the strategic considerations when deciding whether to continue to pursue an application or not?
Yes, I think really once you're at final, it's a good idea to take a step back in every case. And I think really the highest level question is, what strategic value does this case have, if any? So what comes underneath that are some of the things that are on the claim or on the slide here. Is this patent and the claims tied to a product? Is that product in production? Are we selling it, making it? How significant is the product for the company in terms of revenue, market, whatever, other factors, as well as the ability to protect or fence out competitors and competitive products. So that's another sort of strategic consideration. And then, of course, you're looking at the claims. If you've gotten to the point where the claims are quite narrow and quote unquote easy to design around, that is certainly a factor of whether or not you want to continue prosecuting and pursuing the case. Because if you go to appeal or RCE, basically anything other than getting an allowance in that after final context, there's a substantial amount of cost for that individual case to do that. So other considerations are listed here. Design around possibilities. Is this a set of claims that doesn't? It's relevant to our product, but it's really actually going after other ways of doing the thing that we're doing that competitors might try to use to design around claims we've got in other patents. If you've got litigation going on that's related to a product or to this particular patent or a family of patents to which this patent is related, that is certainly something you want to know about and actually docket and mark in the file, because there's special considerations in that situation. Looking at the application itself, a lot of times applications are filed, the claims go off in a certain direction, but the application actually includes a wealth of information and examples in the specification, or more accurately in the detailed description and the figures, that are either outside the scope of the claims that are currently being pursued or take a different approach to similar scope coverage. Those are all things that you can mine, a lot of times we call it, to pursue additional coverage in the same application through some of the options that we've talked about, particularly in RCE.
Good. Well,
go ahead, Ann.
That's good, Tim. And not just, to get the best possible claim coverage in an application, it's more than just having information go from the law firm attorney to the in-house counsel. It's really important that information be fed back to the attorney responsible for prosecution too. So if things like the client's product design changes or the product plan changes, it's really helpful for the prosecution attorney to be aware of that, know about that, particularly as they're working on claim amendments, for example. Likewise, any information that the client has about their competitor's product or product designs or product direction is also really helpful to have be fed back to the attorney managing the prosecution. And I'm sure there's other things. Tim, do you have any other examples?
Yeah, I think at this point, it's information from your client, and in particular the inventors or technical contributors, can be really important at this point in the process. So an example is really digging in technically to the prior art and the invention that's covered in the claims, and getting relatively specific and detailed about what is it actually that the prior art is disclosing and teaching, and how is that different than in the invention. And that is something, particularly it really depends upon the application and the content, the substantive content. So if it's more technical, the client's input is critical at that stage of the game.
True. Good. All right. Well, we've been focusing a lot on the attorney level interactions, but let's get back to the more operations aspects of this. Peter, can you talk us through an example checklist that a law firm might have internally for their operations process when a final office action is received?
Sure. A lot of this may be fairly routine to many of our participants today, but all the same, very important. Verifying that the action is final seems pretty straightforward, but it's not always. Verifying what's in the action versus what's in public pair. And then verifying that you're even, appropriately docketing the response period, that your 2-month due date is on the 2-month due date, and that you have a process in place for capturing all those final deadlines, so that we don't inadvertently abandon the case that we want to keep alive. If you receive a final office action and this was a track 1 prioritized exam case, if you have any special procedures around flagging or heightening the importance of a track 1 case, that's now ended with this final office action. So you may need to forego a procedure for example, if you don't allow for docketing extensions of time in a track 1 case. Now there are extensions of time available, so you need to docket appropriately. And then, one thing we touched on already is that if there's any uncited references in the file that need consideration, that's another thing you'll want to consider here. And depending on the size of your organization and the separation of duties between a paralegal, a docketing department, a legal secretary, these items could be done on the front end, on the intake by a docketing department. They may end up being all verified by a paralegal who maintains the docket. So that will vary based on the size of your organization and how much specialty departments you have.
So, okay, you started to get to this in terms of who might be responsible for these tasks, and it could be different people within the organization. How are these items tracked? How do you know these are getting done?
Right, and I'll use the example of Foundation IP for us. Is we try, since it's an open-ended docketing system, we try to populate as many due dates as possible, whether those are due dates for reporting to the client, due dates for having a follow-up meeting, or for the actual deadline, the statutory deadline for responding. You can do it that way, and then it's on a docket assigned to a specific individual. Another way to go about it is you could create reports based on the intake of these final office actions, and based on the report when things need to get done. So that is, those are 2 ways. One other way to go about tracking these items is using, an Outlook calendar. Maybe you have a secretary that's responsible for populating tasks in someone's Outlook calendar to make sure these are any deadlines are adhered to.
Good. All right, so that was what happens when an office action comes in. Now let's talk, oops, I jumped ahead. Let's talk about when a response is finalized to that office action. What would be some examples of things a law firm might have on their operations checklist to do at the time a response is being filed?
Yep. On the intake side, as I mentioned, that could be done by a document department or paralegal or other. In the typical law firm environment, the paralegal is probably responsible for, review and performing the tasks in this checklist for responding. Confirming you have the right response document and the correct amendments is critical. Confirming that you are paying all the correct fees if you're filing an RC, a notice of appeal, the extensions of time. Checking, once again, if any arts come in from when you receive the office action to your period once you intend to respond, that may change the way in which you respond. Maybe if it's critical art, an RC is favorable here, that you should pursue that route versus an appeal. Has an interview request been considered and summarized? If you are, have you considered the after final pilot program and what is required to participate? And if you had a double patenting rejection in the final office action, can it be deferred or avoided? A lot of these questions will be questions raised by, say, a paralegal, in conjunction and working with an attorney to make sure you're looking at all the different things you need to consider before responding.
Okay, so is it similar to the checklist for the office action received in terms of, could be different people within the organization doing it? How might you track these things? Where would you track them? Who would do them?
Yeah, and I'd say these are more likely not docket items. This would be more like a checklist item that you may have. Mm-hmm. Depending on your company, the checklist could be a checklist that is populated in an Outlook task, or it could be a checklist that has a central repository, or it could be something that's actually built into your workflow that you need to complete this checklist in order to proceed with filing your response.
Okay, good. All right, thank you, Peter. That's really helpful. The last thing that I just want to share is some examples of analytics that people are starting to use when they're making prosecution decisions. So if you're at this point in the process where you have a final office action and you're deciding, do I file an appeal? Do I do an RCE? Do I just let this one go abandoned? There's a lot more data available than there used to be. I've got some examples on my next few slides of some prosecution analytics down to the examiner level. So the one that I'm displaying right now shows a particular examiner, this examiner's art unit that he is in, and then the allowance and abandonment rates. So the one on the far left is that individual examiner's allowance and abandonment rate, with the blue being the percentage of that examiner's cases that are allowed versus the gray. Oh no, I'm sorry. The blue being the percentage that are allowed versus the gray being the percentage that are abandoned. And then looking at that relative to that particular class that matter is assigned to and the art unit that matter is assigned to. So in this example, it's rather unfortunate because the examiner's allowance rate appears to be lower than the general class and art unit allowance rate for this particular matter. And this data is becoming more and more available than it used to be. It could be so data like what I'm showing is something that we're making available, or will be soon offering to our docketing customers at Black Hills. But this is available through other sources too. There are commercial subscription type sources that I know you can find out there, where you can subscribe to examiner level prosecution data similar to what I'm showing you here. Or if you didn't need that low of a view of the data, even just from the USPTO, there's a lot more data available than what there used to be. the USPTO's dashboard, or I think they call it the data visualization dashboard, for example, today has information on the pendencies and allowance rates in different technology centers, for example. So even that level of data, which is publicly available, can potentially be useful when you're at this point in the process and trying to decide what to do. So, Tim, I'm curious, how would you, as an attorney at a law firm, use data like this? Do you want your clients to have this information? Would you just use it yourself? Would you apply it to your client or provide it to your clients? How would you use information like this?
So I think that's a good question, Ann. And I think first of all, I do think that these analytics are a great, sort of technological step for people holding IP portfolios. But at the same time, I would say the client has to be fairly sophisticated and have a fairly large portfolio to really be systematically using these analytics to affect decisions. Now, with that said, certain analytics are really helpful, like this one that Ann is showing that shows it basically tells you this examiner is tough compared to everybody else. So it's not that this class or this art area is necessarily as tough as the examiner. That's a really important piece of information in the context that we're talking about today after final practice. Another interesting one to know about is how often does the examiner go to appeal? And then what is the examiner's allowance rate after appeal? So certain of these metrics can be very useful, but I think right now we're sort of in the very beginning of this, and it can be overwhelming for some clients, and therefore not useful because it gets to be confusing and just too much information. But on the other side of it, some clients have a large enough portfolio and are sophisticated enough in their own departments and infrastructure that they can make use of this data, and it can be helpful for analyzing your portfolio, managing it, looking at which law firms you're using, which groups are having more or less success, as well as picking out individual strategies on individual cases.
Yeah, certainly there's a lot more objective data that's available than it used to be when it was just word of mouth within the law firm of, oh no, you got that examiner.
Yeah.
But I have a couple more examples, and Tim, you mentioned, looking at allowances versus rejections, and when you brought that up, I advanced to the next slide because this is just another example of some types of analytics that are available to compare the examiner to that particular class and that particular art unit. And then likewise, I think you also said it would be interesting to know how often does that examiner go to appeal. So here's another example of some analytics. Again, this is for that same examiner that we were talking about, and shows the disposition of the various matters currently assigned to that examiner. And you can see on this view how many are at the appeal stage. So there's a lot of useful information out there, and you have to decide, depending on your particular situation, how you want to use it. But this data is there, and I wanted to make that available to people, or make people aware that it was there. So let's see if we have any questions. All right, so we do have some questions in the queue. I'll start with the first one. What are the advantages and disadvantages to filing a response to final compared to filing an RCE when the final response will include amendments to the claims? So that's a strategy one. Tim, do you have thoughts on that?
Yeah, so I would say one big thing there is, if you are going to amend the claims, generally speaking, I would say do file the response after final, and try to elicit an advisory action from the examiner. And the reason for that procedurally is that if you get that advisory action, essentially, and depending upon what the examiner says in it, but essentially the examiner is prevented procedurally by rule from making the action, the next action after you file the RCE, because the examiner in the advisory action is saying, I'm not going to enter these amendments, and the case is not in condition for allowance. So then after that, the procedure is to file the RCE and resubmit or to reference the amendment that you already filed. In that situation, if you get the advisory action, the examiner can't make the first action after the RCE final. Why is that important? Because you don't want to be back in the after final box after you pay for and file an RCE. Ann?
Sorry. Good, Tim. Thank you. Here's a very specific question. It sounds like a particular circumstance. My appeal didn't result in any allowance. It's over a year now. What options do I have to revive my application or start a new one? So I'm interpreting that as if it didn't result in allowance and they're asking about revival, that the matter's gone abandoned and it's been over a year. Generally, with notices of abandonment, assuming there was an actual notice of abandonment issued, you have 2 months to file a petition to revive. I guess the other options out there would be dependent on whether the technology had been publicly disclosed. If there has not been a public disclosure, you could still file a new application. If it has been publicly disclosed, then you likely have a bar from going forward. Tim, any other thoughts on that?
Not really. Yeah, it's a tough situation to be in, probably after a year.
Okay, I'm going to turn the next one to Peter. This is more procedure-oriented. What are the procedures, deadlines, and fees for filing an AFCP, so after final consideration pilot program?
So the PTO has a form that's best utilized for this. I think it's the SB 434 form that it lays out the requirements as well as a willingness to participate in the program. I don't believe there are any fees related to participate in the program other than fees that are normally due with the response. So if you have an after final and you have to pay a 1-month extension of time, those fees still apply. In general, the requirements are that it's a non-provisional a utility application or design application, that you need to submit a response with your request to participate in the program, as well as amending, I believe, at least one claim and not broadening any claims. And then also acknowledgement that you'll participate in an interview with the examiner.
Good. Well, that program was certainly set up to try to incentivize getting cases resolved and allowed rather than continuing in the pipeline through an RCE. So it would make sense that they wouldn't put additional fees on. I think they're trying to encourage getting things wrapped up, right?
Right.
All right. Thanks, Peter. All right. If you reply to a final office action after 4 months with a 1-month extension, do you need to file an RCE or just the 1-month extension, or both? So Peter, this gets to the timing, and I think you got into this a little bit earlier, that depending on where you are at the process, it will affect what you need to do. So this, to me, says they're basically at the 4-month or later date, right?
And I think their question is, if I'm paying an RCE fee and I'm past in the extension period, do I also have to pay those extension fees? And you would have to pay those extension fees in order to get the RCE considered.
Okay, so no way around the extension fees.
No, you could try to withhold them, but the USPTO has a way of taking those fees from you, so that would be required.
Okay. How many extensions do you get for an appeal brief if you are using the USPTO decision of the pre-appeal brief? 1 month date is later than the 2-month date from notice of appeal. I'm not quite, can you interpret that one, Peter?
I think so. And, regardless of whether or not you're on the timeline off of your notice of appeal filing, or if you're on the timeline after you file a notice of appeal, let's say with a pre-appeal brief and the decision doesn't come for 5 months. Both of them allow you up to 5 months of extensions. So if you are, you get a very early decision on pre-appeal, and then you're running off of your appeal briefs due 2 months from your notice of appeal filing, you have 5 additional extensions of time available. If it's a really delayed decision on appeal, you get 1 month free after that to file your appeal brief, and then you get 5 additional extensions of time available.
And that's a great question, because there are very few things with the USPTO where you get 5 months of extension available, but the appeal brief is one of them.
Right, and I believe, and don't quote me here, but I believe that still runs off the receipt of the notice of appeal at the USPTO. So if you really want to
stretch it out for every single day,
you could mail by U.S. mail your notice of appeal, and it wouldn't be the date you mailed it, but the date received by the PTO plus up to 5 months of extension.
I'd forgotten that, and so many of our listeners are probably only used to the e-filing of these documents, but there were things like that when express mail filing was more common, and I'd forgotten about that.
Yeah, and that creates its own other problems of actually locating a post office. So that you can go find and actually mail your deposit.
Okay, good. All right, that's all the questions that we have. I just wanted to note, if you have questions about Black Hills IP services or processes, please contact Jim Brophy, and his contact information is listed on this slide. Oops, went one slide too far. The next operations webinar that we have in this series is 1 month from now, on March 21st at 1 p.m. Central Time, and that program will focus on best practices for managing notices of allowance, issue fee payments, and continuation practice. So Peter and Tim, thank you very much for sharing your information today, and thank you to our audience for participating. We hope that you will join us for this and other webinars in the Operations Excellence webinar series going forward. Thank you.